I'll be discussing the Second Amendment. The Second Amendment states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. This amendment was passed by Congress September 25, 1789, and ratified December 15, 1791, as part of the 10 amendments comprising the Bill of Rights. Now, the importance of the Second Amendment is the question, is it an individual right or is it a collective right? Now, the Bill of Rights was created as a protective of individual rights. So why would the Second Amendment alone be intended as a collective right and a restriction on the individual's rights? To many individuals today, the guarantee of the individual right to bear arms may seem antiquated or irrelevant, but it is as important today as it was during the constitutional era. It may be used as protection against those who seek to do us harm or as a deterrent against a tyrannical government. James Madison stated, Americans have the right and advantage of being armed, unlike citizens of other countries whose governments are afraid to trust the people with arms. Now, America was formed based upon freedom and individual rights. As a reminder, though, with every right comes a responsibility, and we must have a responsibility to control the firearms and use them properly and ethically. Complications and challenges related to the Second Amendment may have to do with, I would say, the language at the time. It could be considered problematic because it was written at a developmental time in American history. Some historians have suggested that the first part of the amendment, which states a well-regulated militia being necessary to the security of a free state, is unnecessary. It does not say the right of the militia to keep and bear arms shall not be infringed. It specifically says the right of the people. Now, these people had just completed a war of independence from a tyrannical state militia. Some people argue that that was then and we are in the now, and it doesn't apply. Some of the court cases related to the Second Amendment. On June 26, 2008, in the District of Columbia versus Heller, the United States Supreme Court issued its first decision since 1939, interpreting the Second Amendment to the United States Constitution. The court ruled that the Second Amendment to the U.S. Constitution confers an individual right to possess a firearm for traditionally lawful purposes such as self-defense within the home. It also ruled that the two District of Columbia provisions, one that banned handguns and one that required lawful firearms in the home to be disassembled or trigger locked, violated this right. In another court case, McDonald versus Chicago, 2010, the Supreme Court invalidated Chicago's handgun ban and held that the Second Amendment applies to the states as well. There were several other Supreme Court cases, United States versus Cruikshank in 1876, which dealt with the members of the Ku Klux Klan depriving the black victims of their basic rights such as freedom of assembly and to bear arms. In 1886, Presser versus Illinois, and in this one, Presser stated that the Second Amendment aside, the states could not prohibit the people from keeping and bearing arms so as to deprive the United States of their rightful resource for maintaining the public security. In U.S. versus Miller, 1939, the Second Amendment cases, U.S. versus Miller is the most miscited, intentionally and otherwise, by the lower courts, not to mention the news media, textbooks, and encyclopedias. Some courts have acknowledged the true holdings of Miller, but then simply disregard them. Applications to modern society. Modern debates about the meaning of the Second Amendment have focused on whether it protects the rights of individuals to keep and bear arms, or instead, a right of the states to maintain militia organizations like the National Guard. The debate has shifted primarily because of subsequent developments in the Constitution and constitutional law. You have to remember back when this was created, the massive shift of power from the states to the federal government generated one of chief objections to the proposed Constitution. Anti-federalists argued that federal control over the militia would take away from the states their principal means of defense against federal oppression and usurpation, and that European history demonstrated how serious the danger was. James Madison, again quoting him, for one, responded that such fears of federal oppression were overblown, in part because the new federal government was structured differently from other European governments. But he also pointed out a decisive difference between America and Europe. The American people were armed and would therefore be almost impossible to subdue through military force, even if one assumed that the federal government would try to use an army to do so. In the Federalist, number 46, he wrote, "Besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached and by which the militia officers are appointed forms a barrier against the enterprises of ambition, more insurmountable than any which a simple government of any form can admit of. Notwithstanding the military establishments in the several kingdoms of Europe, which are carried as far as the public resources will bear, the governments are afraid to trust the people with arms, and it is not certain that with this aid alone they would not be able to shake off their yokes."